Good afternoon, everyone. I hope you can hear me.
Good afternoon.
So my name is Helen Namisi, and I am the Vice Chair of the LSK Nairobi branch. On behalf of the branch and on behalf of our Chair, Eric Theory, I'd like to welcome you to today's webinar. The branch has taken a keen interest in this topic that is being discussed today. Following the rise of the digital age, which has come with ease of communication, cloud storage, diversification of research methods, new investment strategies. For example, we have the Bitcoin and such. We have also seen business being created for hackers. We have been exposed to the reality of data theft. And somehow this digital age has also made corruption an intricate affair. So today's session will focus on data protection from the legal perspective. Data protection is a legal topic that impacts both the public and private sectors. Living in a data-centric world with the increased significance of outsourcing, technology advancements, and information usage in the society, the law governing this field is becoming increasingly important. What we need to consider then is whether the Data Protection General Compliance and Enforcement Regulations 2021 cover all legal concerns for law firms and the clients that we interact with. And so, excuse me, sorry. And so this afternoon, we are going to find that out. We have a speaker who is an expert in the field and a rising mogul in the legal sector. And without much ado, I would like to introduce to you Mr. Mugambi Laibuta. I will tell you a little bit about Mr. Mugambi Laibuta, and hopefully I will be able to capture all that is impressive about this gentleman today. So Mr. Laibuta is an advocate of a high court. He's a trained mediator. He's a legislative counsel and policy analyst, plus a private and data protection specialist. He is currently a PhD candidate at the University of Witwatersrand, researching and writing on privacy and data protection in Kenya. He provides consulting and advisory services in policy development, governance, rule of law, constitutionalism, legislative drafting, digital rights, internet and technology law, privacy and data protection. You've had that whole list. As I said, he's quite impressive. He also teaches legal writing and legislative drafting at the Kenya School of Law. On privacy and data protection, Mr. Mugambi has carried out data protection impact assessments and drafted data protection policies and documentation for regional institutions in East and West Africa. He has carried out similar consultancy assignments for private and public sector clients in the region. He has also drafted a data protection bill and regulations for a state within the Horn of Africa. Maybe you can ask him about that, or you can guess which country it is. He trains institutions on their obligations in data governance and works with them to ensure compliance with universal data protection principles. In addition, he has been involved in constitutional review processes in Kenya, Sudan, South Sudan, Somalia, and Chile. He also runs a digital law blog, which is www.laibuta.com. When you do have a chance, please log in and see what it's all about. And has a podcast, Ole Law Podcast, where he discusses technology and the law, privacy, data protection, cyber crimes, freedom of expression, rule of law, and constitutionalism. Ladies and gentlemen, I don't need to tell you that this man is impressive. And so I am inviting you to sit back this afternoon and listen to everything that he has to offer us. His expertise, his wisdom, his knowledge in this particular area. And I'm sure at the end of this webinar this afternoon, you will agree with me that indeed we got the right speaker for this particular topic. So with that, Welcome, Mr. Mugambi Laibuta.
Thank you very much, Senior Helen, for that great introduction. So I have some slides to share shortly. And if you have any questions, kindly just post your questions on the chat, and then we shall deal with them later. Thank you. So let's allow me to share my screen. I think my screen is visible. You can see what I'm sharing.
Yes, we can.
Okay. So today I'll be talking about data protection in legal practice. And just to start, so I have this slide, which I like beginning my sessions with. So think about where you work and which of these photos represent where you work. 1, 2, 3, and 4. Just tell us on the chat and tell us why. So just 1-2 minutes. Which one represents where you work, whether it's a law firm, whether it's corporate, whether it's in government. Just let us know. Which one do you think, which one represents where you work and why? Then we shall revisit, so just let us know that in the chat, and then we shall revisit that. So this presentation basically is based on the Data Protection Act. I have consciously avoided talking about the regulations because the draft regulations, whether it's the general regulation, the compliance regulations, and the registration regulations, are still in draft form. Around April, March, the Data Protection Commissioner shared those 3 documents. There was some public participation, and the Commissioner with a committee appointed by the ICT Cabinet Secretary retreated to look at the views that we gave. And we hope that the Office of the Data Protection Commissioner, together with the ICT Cabinet Secretary, will share the revised version, of course, before gazettement. Now, when we are thinking, so my presentation is basically tailored to legal practice. And one of the questions that we need to pose and ask ourselves is whether the Data Protection Act applies to us as lawyers, as legal practitioners. So Section 4 of the Data Protection Act guides us on this matter. You can call it the jurisdiction clause or the territoriality clause, because it's what tells us whether the law applies to us. So when you look at Section 4B of the Data Protection Act, it says that the act applies to the processing of personal data by a data controller or data processor who is established or ordinarily resident in Kenya and processes personal data while in Kenya. So for us as law, of course, our law firms or legal consultancy, the institutions we work with mostly are established in Kenya, they're ordinarily resident in Kenya, and we process personal data while in Kenya. So that means that the Data Protection Act applies to all of us and the institutions we work under or the institutions we own. Then 4B2 talks about that by a data controller or a data processor who is not established or ordinarily resident in Kenya, but processes personal data of data subjects that are located in Kenya. So basically what this means, if you work for a multinational company, and it might not be resident in Kenya, but it deals with personal data of individuals that are located in Kenya. Please note that it doesn't talk about Kenyan citizens or Kenyan residents. It just says so long as the data being processed is for an individual, and I shall look at some of these definitions shortly. So long as these individuals are located in Kenya, then the Data Protection Act applies. An example that I could give would be Twitter. Twitter is not established in Kenya. It is not resident in Kenya, Facebook, the same, Instagram. So these multinational companies that mine a lot of our data, so long as they are mining our data and we are located in Kenya, then the act applies to them. So there are various actors within this law. As you've seen, I've talked about the section 4 talks about data controllers, data processors. So there's the individual who is the data subjects, and I said I shall be looking at some of these definitions shortly just to give clarity on what we are talking about. The data controllers, data processor, data protection officers, and the data protection authority, which is the office of the data protection commissioner. So a few definitions. Data controller basically is a natural person or legal person, public authority or agency, which alone or jointly with others determines the purpose and means of processing data. An example here I will give is that if you own a law firm or you're a partner at a law firm, that law firm has employed certain individuals. You have employed associates, you have employed clerks, you have employed messengers, etc. You perhaps have employed consultants. So at the point at which you are hiring these individuals, there's certain information or personal information or data that you collect from them, and you determine that you're collecting this data for purposes of the employment. So at that point, your law firm is the data controller. Another example I could give could be Java. Let's say you've gone to Java, you've bought a cup of coffee, then you've paid via M-Pesa. Then Java wants to look at the message to see the M-Pesa message to see whether you've paid. So in that instant where Java is confirming, is getting your phone number, your M-Pesa details to confirm whether you paid, they are the data controller. Then we have a data processor. You'll find a lot of law firms will fall a lot under data processor. And this is basically what it means. So this is a natural person, public authority who processes personal data on behalf of a data controller. Look at it this way. You are a law firm, you are engaged in, say, conveyancing, or you're engaged in debt. Let me use another, you act for a bank. You are carrying out debt recovery on behalf of a bank. So what the bank does, the bank is providing credit facilities to its customers. So there's an agreement with their customers that we shall provide you this credit facility, but you should give us some personal details. You need to give us your ID, your name, your contact details, your next of kin, etc. But at some point, this person defaults, and the bank engages the services of your law firm to recover this debt. So what this happens is that as the law firm, you are not the person who was providing the credit facility, but the bank engages you to do debt recovery on their behalf. So in that case, you are the data processor. Then the data subject, of course, is any identifiable natural person. In South Africa, the Protection of Personal Information Act says even juristic persons may be regarded as data subjects. That's not the case for us. But a data subject is basically you and I, who are subject to personal data. And this identifiable person, anything that can identify us, whether our name, ID number, our location, online identifier, this is our email, our Twitter handle, our Facebook handle, our LinkedIn handle, our economic, cultural, and social identity, anything that can identify us, we call it an identifier, it's data. And personal data is basically any information that can identify you, any information that can identify me. The example that I've given of your law firm acting on behalf of the bank, the customer who has defaulted and whom you are chasing, to use that simple term, who you are chasing or you're going after to get to ensure that they pay the bank, that person is the data subject for this purpose. So the bank is the data controller that was offering those credit facility. Your law firm is the data processor being under instruction of the bank, and the person whom the data relates to is the customer. Now, as legal practitioners, we handle a lot of sensitive data. And this is where we need to pay close attention, because if you look at Section 62 of the Data Protection Act, and I'm going backwards. When you look at Section 62 of the Data Protection Act, it talks about penalties by the Data Protection Commissioner. For example, 62.2 says, in deciding whether to give a penalty notice to a person and determining the amount of penalty, the Data Commissioner shall so far have regard to. So one, there's the nature, gravity, and duration of the failure. B, there's the intentional negligent character of the failure. C, any action taken by the data controller or data processor to mitigate the damage or distress suffered by the data subject. The degree of responsibility of the data controller and data processor taking into account technical or organizational measures. E, any relevant previous failure by the data controller or data processor. The degree of the cooperation with the data commissioner. And G, to the categories of personal data affected by the failure. The categories of personal data, we have sensitive data, sensitive personal data, and we have other data. So when you read Section 62.2G, it says when the data commissioner is investigating to see whether there have been failures in complying with the act, we look at the categories of personal data that is involved. And when you look at Section 2, it defines sensitive data as somebody's race, health status, ethnic origin, conscious, belief, genetic data, biometric data, property details. Colleagues who are dealing with, who are in conveyancing, you get property details of your clients. In probate and administration, property details are key. Marital status of your client, family details, including names of persons, children, parents, spouses, people's sex, people's sexual orientation. So when you read 62.2G, you look at the data commissioner will be keen to see what kind of categories of data you are handling within your institution, and in this case, your legal practice. Now, when we are talking about processing of personal data, it's basically anything, any operation that you are undertaking. So when you're collecting information, recording information, organizing, structuring it, storing, altering it, sharing that data, disseminating that data, all this is processing that is governed by the Data Protection Act, because the Data Protection Act says what kind of data, it looks at what kind of data you're processing, how you're processing that data, why you're processing that data. Now, what I call the Bill of Rights of data subjects, if I could use that word, Section 26 of the Data Protection Act talks about the rights of a data subject. So as a legal practitioner, and you will find that some of these provisions that are there under the Data Protection Act, they overlap with our professional obligations as practicing advocates. But anyway, Section 26 talks about the rights of a data subject, your rights, my rights, the rights of your clients, the rights of your employees. One, we have a right to be informed of the use to which the data is being put. So the question is, for example, if you're onboarding a client, let's say a client comes to you, they want to purchase property, for example, or they want to sell property. When you're carrying out due diligence and you're collecting information from them, do you tell them, well, we need your ID because of reason 1, 2? Do you tell them we need a copy of the title deed because of this and that? So one, you and I have a right to be informed of the use to which our data is going to be put. What are they going to use our data for? Then B, access to their personal data in the custody of a data controller or a data processor. Here you see, as lawyers, professional obligation, you have the obligation to keep your clients informed. Your client can come and say they want a copy of their file. So when you look at Section 26B, really it's what we have been doing as legal practitioners, but might in a different context relating to one's personal data. Section 26C, you and I have a right to object, or your clients have a right to object to processing of all of their personal data. But if somebody is saying they don't want some of their data to be processed, of course you tell them the consequences of that. Let me give an example. Somebody comes and say they want to purchase some land, or they want to buy some land, and one document they don't want to provide is their KRA PIN certificate, or they don't want to provide passport photo. Then you tell them, you know what? it's your right to object to this, but then the transaction cannot move forward. Then 26D, we have a right to correction of false or misleading data. We also have a right to deletion. So there's a right to correction of false or misleading data. There's also the right to deletion of false or misleading data. When you look at section 27, exercise of the rights of the data subject, again, happens, I mean, this is what happens in legal practice. Somebody, where the data subject is a minor, of course, you need a parent who has parental authority or a guardian. Where somebody has a mental or other disability by somebody duly authorized as their guardian or administrator, something we deal with as lawyers, we deal in legal processes, or any person who has been duly authorized by the data subject. I mean, so if somebody has been given express authority by the data subject, then they may act on behalf of the data subject. And when we are thinking about all this, is that always also think there might be harms which may be monetary or non-monetary, relating to how we handle personal data of our employees, of our clients, or how we handle personal data, like the example I gave, you are collecting, you are carrying out debt recovery on behalf of a financial institution. So what if that data leaked, if there was a data breach? So there might be monetary loss for breach of the rights that are set out under section 26 of the Data Protection Act. There might be non-monetary harm, for example, physical, reputational harm, emotional harm, chilling effect, disturbance. People may be vulnerable. So if intimate information about an individual is out there, that may cause them both emotional and mental harm. So we always think about what will be the harm if we don't comply with the Data Protection Act. Under the Data Protection Act, in its implementation, we say that it is it's risk-based compliance, because you're always looking at what will be the risks to the rights of the data subjects. So legal practice is not exempt from the provisions of the Data Protection Act, but there are some gray areas that I will talk about. For example, the Protection of Personal Information Act of South Africa is very express on a certain issue. Under section 86 on communications between a legal advisor and a client, they say it is exempt. So it says, subject to the provisions of this section, the powers of search and seizure conferred by a warrant issued under section 82 must not be exercised in respect of any communication between a professional legal advisor and his or her client in connection with the giving of legal advice to the client with respect to his or her obligation, liabilities, or rights. Any communication between a professional legal advisor and his or her client, or between such advisor or any other person made in connection or in contemplation with proceedings arising under this act, including proceedings for the court and for purposes of such proceedings. So the Protection of Personal Information Act in South Africa is quite clear that because the Data Commissioner has certain powers, has powers of search and seizure, has preservation order powers under the Data Protection Act. But our Data Protection Act doesn't have such a provision. So which means, is it possible that the Data Protection Commissioner can come, carry out an audit in a law firm, and now start taking up information that relates to your client? But to go around this, I think as colleagues, we need to think about provisions of section 74 of the Data Protection Act that says that the Data Commissioner may, for purposes of this act, develop sector-specific guidelines in consultation with relevant stakeholders in areas such as health, financial services, education, social protection, and any other area that the Data Commissioner may determine. So in my view, I think as the legal profession, we need to think of coming up with guidelines or with sector-specific guidelines that mirror what section 86 of the Protection of Personal Information Act of South Africa provides for. But that said, we still have Rule 7 of the LSK Code of Conduct, where communication between an advocate and a client is protected by the rule of confidentiality, advocate-client confidentiality. There should not be unauthorized disclosure of of a client's confidential information, which may result to misconduct. But now what we are seeing is that the interplay between our professional obligations about the lawyer-advocate, the advocate-client confidentiality principles and the Data Protection Act. Of course, if we breach the LSK Code of Conduct, we may be cited for professional misconduct. Then it shows when you read the Data Protection Act, this client could also say, this advocate disclosed my personal data, and this person can make a complaint to the Data Protection Commissioner, which means that it exposes us as legal practitioners even more. We have greater exposure. And then, of course, there's the evidence, section 134 of the Evidence Act, that basically talks about the issues of not disclosing information unless there's express consent from the client. And shortly I shall discuss what consent means for us as legal practitioners. So as legal practitioners, we are, as I indicated, we may act as both data controllers and data processors. I said an example as a data controller, where you are hiring staff for your law firm, there you are the data controller. When you're acting on behalf of a client, let's say the example I gave of a financial institution, there you're a data processor, and you must use the personal data given to you by the bank, who is the data controller, under the specific instructions of the bank. So this I was saying, legal practitioner, we deal with data from employees, from clients, from individuals related to clients. For example, in probate, in conveyancing, you not only get information about your client, you get about their spouses, about their relatives, their children, etc. So in all this, we are employers as lawyers. We use technology that harvests data. We collaborate with other professionals, and there's need to use the personal data, and we provide legal services. So this said, and think that we might be cited for professional misconduct, for breach of personal information of a client, and also maybe a complaint may be made against us to the Data Protection Commissioner. What could we do as lawyers? So we need to think about the data protection principles that are set out under Section 25 of the Data Protection Act. These are basically about lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, storage limitation, security, and accountability. And I shall deal with each separately. So lawfulness of data basically means we follow the law when processing personal data. The Constitution of Kenya's Article 30 provides for the right to privacy. The Kenya Data Protection Act, there are also regional data protection regulations in certain areas of the continent. We need to be looking at what could be the risks to the data subject, what could be the risks to our members of staff, what could be the risks to our clients in relation to how we process their data, how we collect their data, how we analyze their data, how we store their data, and how we share their data. There are issues of free and prior informed consent. Do you seek consent? The good thing about us lawyers, we get instructions from the client. So a client comes, gives instructions, and with those, especially when they are written instructions, they say, I want to purchase this piece of land. Here are the documents. This is my name. This is a copy of my ID. These are my products. So you've already, the client, by providing you all this information and instructing you to represent them on that matter, there is consent. You've already gotten their consent. Then another way you can process personal data is contractual obligations. For example, as an employer, you have a contract of employment between you and your associate, between you and your researcher, between you and an intern. And in that contract of employment, you indicate to them the certain personal information that they should provide to you for purposes of employment, for purposes of paying statutory deductions, NHIF, NSSF, etc. There's also for public purpose. For example, in the judiciary investigations, also look at Section 51 that talks about exemptions. and Section 30 that talks about lawful processing situations within the Act. Also, I've talked about this obligation to comply with the law. So sometimes we process personal data. For example, you can't refuse to pay taxes. So for example, you maybe act for a client. When you charge VAT, they'll need your VAT certificate. If it's withholding tax, they will need your PIN number, etc. So when you're thinking about conditions of consent, of course, when you're carrying out your client interview, you should be very clear why you require certain information from them, seek consent from them to represent them. I said it's better, it's easier for us as legal practitioners because once you get those express instructions to act for them, it acts as consent. And of course, under Section 32, a data subject has a right to withdraw their consent at any time. That's why somebody says, hey, Wakili, I don't want you to work for me anymore. Give me my file. Here's your money. I'm going to another lawyer, which is fair enough. And life continues. So as a law firm or as a legal practitioner, certain information that you should be providing to your client under Section 26, for example, you need to tell them what personal data are you collecting from them? Why do you need that data? You may need that data, for example, I said, to represent them in a matter in court, to present them in a commercial transaction, in a conveyancing matter. You need to tell them what you will do with their personal information. For example, tell them, we need your passport photo, we need your PIN certificate, etc., because it's necessary when you're filing this and that document in the relevant registries, etc., or it's required by KRA, it's required by Visa Act. If you're going to share their data with any individual, you need to inform your clients how long you'll keep that data. How do you keep the data secure? Remember that slide that I started with? Are you that law firm or are you photo 1, 2, 3, or 4? You need to inform your clients about their rights, that they have a right to be informed what you're going to use their data for. They have a right to object. They have a right to access their data. They have a right to correct or delete false or misleading information. And when we're talking about purpose limitation, we're basically stating that as a law firm, as a legal practitioner, don't use the data, the personal data of your client for the purpose it was not intended to. For example, now you can tell, let's say you're active for an insurance company, and the insurance company say, Wakili, give us the list of your clients and their contacts so that we can sell them insurance products. That you cannot do. Or you are opening, let's say you're an advocate, you're also a farmer, and you have produce from your farm. So you want to send messages to all your clients, tell them now you're providing, you can deliver cereals to them. No, you can't do that, and because that is not for the purpose they gave you their personal data. So if you're collecting personal data for a client, let's say for conveyancing, just use it for that. If it is for litigation, whatever kind of litigation it is, or matter in court, just use their personal data simply for that purpose. Accountability, of course, as you've seen, as a legal practitioner, you're accountable under our professional and ethical obligations. And now we are also accountable under the Data Protection Act, where our client feels that they can make a report to the Data Protection Commissioner. If there are breaches in your law firm or the institutions that you work for or under, or institutions that you own or you lead, you need to report breaches for non-compliance, and the point of reference is Section 43 of the Data Protection Act. You need to have good record keeping. I say good thing about we as legal practitioners. I think most law firms, if not, I think let me use the word most law firms or practitioners will have a very good filing system. And if you work within a law firm, because now this is interesting, we have quite a number of law firms that are within a group, can I call it a group of company or group of firms? So there's an international name. So this firm represents an international brand within Kenya, and they share data with these law firms outside there. So the question is, do they have data sharing or data transfer protocols? contracts, corporate rules that are very clear. What are the obligations of the umbrella of international firms and the local firms in terms of handling personal data of people within Kenya, as we saw the jurisdictional clause form. So that is about accountability. Data minimization. Don't process data that you don't need, only collect data that you require. For example, if you're representing a client in a conveyancing matter, you don't need, you need to know their religion, their political views, their level of education. So you just collect the data that you require. Then there's the issues of data accuracy. Here, of course, there are also legal sanctions or legal effects if you perhaps draft a document with the wrong information or incorrect information. So as legal practitioner, the issue of accuracy is something that we know very clearly. Limitation to retention of data. How long should we retain our data? If you're a firm or company that uses cloud services, does that cloud service have very clear provisions that protect personal data of Kenyans? Or like in my practice, I've seen most of them will say, you'll go to this cloud service provider and say, they'll tell you they comply with GDPR. Why should they comply with the Kenyan law? So these are some of the things that you need to pay attention to if you're using cloud service. If you're using software that, let's say, farm management software, where is it in the cloud? Who is the cloud provider? You need to think about the technology you are deploying. And here, please pay attention. A lot of us at some point, I mean, myself included, we find that we use freeware, where you download software that is free on the net, but it's not really free, because the providers of that software, especially if it's linked to the internet, they will collect some information from you, from the cloud, and they will use that information for whatever reason. So ensure that if you're using cloud services, if you're using software or technology within your firm, that it is really tailored to your firm, really tailored to your institution. There's a very clear contract in terms of the obligations under the Data Protection Act. So as a firm, what are some of the compliance strategies to the Data Protection Act? One, of course, is training. There are certain institutions that carry out training. These I can mention I think there's somebody, could everyone mute? I don't know, I'm getting some feedback, not sure from where. Okay, so you can carry out training. The Kenya School of Law provides training on data protection. Serianu Limited provides data protection training. GM Gama Advocates provides data protection compliance training. So there are various institutions you can go to, and you can get training on the Kenyan Data Protection Act. As a firm, as an institution, you need to know what kind of data, what kind of personal data do you handle within your law firm, a data inventory. And shortly I shall indicate to you what does a data inventory really mean. You need to carry out a data protection compliance assessment. To what extent is your law firm compliant to the security of the data? Do you inform your data subjects about their rights under the Data Protection Act? If you work, Section 24 provides for appointment or designation of data protection officers. So basically, as a firm, I mean, you may not need to hire one, or you could just designate one of the individuals within your lawyers or partners, associates within your law firm to act as the data protection officer. But if you're in corporate, let's say if you work in a bank, if you work in insurance, that insurance company, that bank definitely has to appoint a substantive data protection officer for that institution. Another thing you need to pay attention to as a legal practitioner is whether the institution you own, you work for, has developed institutional data protection policy and privacy notices, whether you have reviewed your contracts or agreements with staff, contractors, agents, and suppliers in relation to your obligations under the Data Protection Act. You need to have data protection clauses. And this is not just the confidential non-disclosure agreements or confidentiality agreements. There are specific clauses that need to appear in in contracts. Then do you record the kind of data you process? So how you demonstrate accountability? Simply, you need to have an organizational structure to deal with data protection within your firm. You need to have a record of processing operations. That is the data inventory. You need to have policies and procedures on how to deal with data protection matters. Contracts, you need to review all contracts to see whether they require clauses that are very specific to data protection. Data sharing protocols, especially law firms. I talked about these law firms within a group. I mean, a law firm, let's say, is, as I said, a law firm, there's a brand worldwide and they are within an umbrella. And one of the law firms is in Kenya and they share a lot of information with each other. There needs to be very clear data sharing protocols. I've talked about training and awareness. You need to continually identify risks to data protection. As I said, now your client can make a complaint against you under the Data Protection Act and against professional ethical obligations. You need to think about your records management. And records management is both physical. I mean, all of us as legal practitioners, we have physical records, we have online records. You need to ask yourself, how secure are them? Are they, both the online records and the physical? How transparent are you in processing of personal data? Do you have an in-house complaints handling process that relates to personal data? How do you respond to breaches, and how do you continuously monitor compliance? So just to, I mean, the data inventory that I talked about, in my view, if you have not carried out a data inventory within your institution, then you will not know how to comply with the Data Protection Act. And the data inventory basically it's a list that tells you that has a list of the personal data you process. It tells you where the data is coming from, whose personal data it belongs to, what kind of personal data it is, whether it is personal data, what is just general personal data or sensitive personal data. In that data inventory, you also need to identify why do you process this data? What is the lawful ground for processing? Lawful grounds, as I said, look at Section 30 of the Act that talks about consent, contractual obligations, legal obligation, public purpose, etc. Where do you process or store this data? Is it physically in a shelf, in your registry? Do you store it in the cloud? If you store it in the cloud, what kind of contractual obligations do you have with the cloud service provider? Also, in your data inventory, it will help you know how long you have to keep this data, help you identify the security measures you're putting in place to protect this data. If you transfer data to a processor, is there a data processor agreement? And whether you transfer data outside Kenya, they say this one, especially for law firms that are within an international umbrella. Why data inventory is important? It helps you craft a data protection strategy. It will help you determine which regulations will apply to you. It will help you classify the kind of data that you handle as a firm. It helps you in data minimization. It's key in helping you carrying out data protection impact assessment. Under the draft regulations, you'll find that one of the conditions for registration is providing a data inventory to the data commissioner. It is a provision I'm very uncomfortable with. I don't see why the data commissioner needs a data inventory to register controllers and processors, but it was there. To help you deal with data subject access requests, I mean, a client needs information, you need to provide them copies of their files, copies of their documents. A data inventory also helps you in data breach response and helps you carry out effective use of data. Now, apart from the LSK disciplinary mechanism, as I said, we have the Office of the Data Protection Commissioner. Under this office, its role is a regulator, is an auditor, is an educator, is an enforcer, is a policy advisor, negotiator, international ambassador, consultant. So as we wait for this office to be fully operational with more funding, because really we're looking at the allocations in the next financial year, the estimates by Treasury. It's quite sad that this office was just allocated just around 50 million shillings, which I don't think it's enough for it to carry out its mandate. But it has all these functions. And we'll wait to see whether this office will either be reactive or proactive. Reactive in that it will wait for breaches to occur, for complaints to be made against you as a practitioner, or it will be proactive. And proactive, as I said, as Law Society of Kenya, as Nairobi Bar, we need to think about Section 74(1)(b), where the Law Society can work together with the Data Protection Commissioner to come out with sector-specific guidelines for us as legal practitioners on how the Data Protection Act will affect our day-to-day practices, especially owing to the advocate-client confidentiality principles. So this commissioner, the Office of the Data Protection Commissioner, can investigate, has the powers to investigate their complaints, to issue enforcement notices. They have a power of entry and search. Remember the provision, Section 86 of the Protection of Personal Information Act of South Africa that protects advocates' client communication. We don't have that specific provision, so it's something to think about. And the commissioner may issue penalty notices and administrative fines. But I think the most dangerous provision for all of us, not only as legal practitioners, but for everybody, is Section 65 that talks about compensation of the data subject. And Section 65 is, it talks about that a person who suffers damage by reason of contravention of this act is entitled to compensation. And 65(4) talks about damage to include financial loss and damage not involving financial loss and distress. So the question, how do you even quantify distress? There have been certain cases, privacy cases, I think one, sorry, I can't remember them often. Anyway, there are provisions where the courts have said the complaint, I mean, the plaintiff did not prove that there were damages. So, excuse me, no damages, no damages were awarded. But the courts may also start issuing very high compensatory amounts. So what does that mean for us and our clients? So there's a business case for data protection. Of course, it reduces our legal risk for non-compliance to Article 31 of the Constitution and the Act. It reduces our reputational risk. It creates an institutional data governance culture. It protects both personal and institutional data and improves data security. The opportunities that are there for all of us as legal practitioners, there are many under the Act. You can be the person helping data control, working with data controllers or data processors to register them under Section 19. You may be appointed as or designated as a data protection officer as a source of employment. You can be carrying out data protection impact assessments under Section 31 and just be a consultant or a legal advisor on that. You may be involved in filing complaints to the data commissioner or representing parties before the commissioner or filing appeals to the High Court. Or you could be representing people who have committed crimes under the Act, Section 71 and 72. You could be engaged in developing in-house or institutional data governance policies or drafting or reviewing contracts that require data protection clauses. So colleagues, there are very many opportunities for all of us under the Act, as we also seek to ensure that our institutions, our firms are compliant. Thank you very much.
Thank you so much, Mr. Laibuta. We really appreciate that session. It's very informative. You've covered so much. We are totally indebted to you. For now, we can cover a few questions that are being asked in the chat section. And the first one is, how will data breaches by multinational organizations, for example, Facebook and the like, be enforced in Kenya?
Okay, I could start with that. So basically, one, we require, my hope is that soon the Office of the Data Protection Commissioner and the Cabinet Secretary for ICT, actually under the Act, it is the Cabinet under Section 71 It is the Cabinet Secretary for ICT that's supposed to develop regulations under the Act. So with these regulations in place, hopefully, so what happens, for example, in the European Union, as we have seen, as you may have noted, the data protection authorities there, they carry out investigations on these multinationals as the multinationals to show cause why the administrative action should not be taken against them. And then if there is no cause, there's no, I mean, the multinationals cannot explain why they are carrying out certain actions. Of course, they are fined, and we've seen various fines by either the French, the French, which is called CNIL, has fined Google. I think it was I think it was 65 million euros. Recently, WhatsApp was also fined by the Irish Data Protection Authority. So, on the issue of Facebook and Cambridge Analytica, the Information Commissioner's Office of the UK fined Facebook for its role in the Cambridge Analytica fiasco. So it purely depends on the actions of the country's data protection authority, and for us, it's the Office of the Data Protection Commissioner. The most interesting thing is that when the ICO of the UK was carrying out investigations on the Cambridge Analytica scandal, it used around 3 million, I think it was 3 or 4 million pounds just to carry out that one investigation. So you can see, for us, where we have an allocation of just 50 million Kenya shillings for the next financial year for the Office of the Data Protection Commissioner, they may not have the right resources to go against multinationals. But if the office had the financial and human resources, excuse me, definitely they can take action, ask these companies to show cause why they should not be fined, or administrative action should not be taken against them. If they can show no proof, then the administrative action is taken against them.
Thank you for that. The next question is on matters consent from regulations issued by the ODPC regarding consent. It has been stated that consent does not exempt the data processor or the data controller from legal liability in instances of unlawful processing of data. A more paternalistic approach to data protection, doesn't it defeat the purpose of giving the data subject?
One thing, and I think one issue that perhaps those guidelines by the Data Protection Commissioner are not clear, is that consent is not the only lawful processing mechanism. It's not the only tool for lawful processing of data. When you look at Section 30, of course, the first one is consent, that a data subject has to consent to the processing. But there is also the performance of a contract with the data subject. There's also the provision relating to compliance with legal obligations. So it is for I think it is for the data commissioner to be a bit clearer on that, because definitely under Section 32 of the Data Protection Act, it is the data controller or data processor that bears the responsibility. The burden of proof is on a data controller or data processor to prove that actually the data subject gave consent. So how do you ensure that, how can you, for example, prove that the data subject gave consent? There are several things you can do. I mean, as I said, for us lawyers, it's easy. You just need the express instructions, especially written instructions from your client. That is express consent. Or if it's within a mobile phone application or a website, you can have people clicking yes, I agree. But also in the EU, that has been taken to task, because is somebody just clicking yes, I agree to my data being collected? Does that really amount to free, prior, and informed consent? So as a law firm, let me just say, as a law firm, get those written instructions that allow you to process. Of course, it's something that we do every day, but now you're conscious that you are not only complying with your professional obligations as an advocate, but you also comply with your obligations under the Data Protection Act. Get those express instructions from your client that will be regarded, inform your client about what data you're collecting from them, why you're collecting it, how you're going to keep it secure, who you're going to share it with, or even a contractual obligation. Let's say you're under retainer, under Section 30, that is a contractual obligations between you and your client. So there needs to be clarification about the Section 30 legitimate lawful processing tools that one can use.
I believe the question has been well answered. One more person has privately messaged me, and they are asking, how do you decide the most accurate lawful basis for processing personal data?
I think that's what I was talking about. Have a look at Section 30. Section 30, the first one, it talks about the consent of the data subject. It talks about being in a contractual obligation, contractual obligations between a data controller, a data processor, and the data subject. Compliance with a legal obligation is another one. For example, taxation or statutory deductions. As an employee, you can't say, for example, that you shall not provide your NSSF, NHIF number, or your PIN certificate because you don't want to pay taxes. No, you must provide that personal data because it is a legal obligation under statute. And that is another lawful way to process personal information. They are also for public purpose, for public interest. For example, the corona pandemic, where we find that people's COVID status is shared between agencies for purposes of fighting the pandemic. But by and large, just look at Section 30. It has a list of legitimate processing operations.
I believe, Mr. Laibuta, you have covered the session extremely well, and we couldn't be more appreciative of that. I mean, you've covered from the data processing to management of those records, even sharing the data sharing protocols that firms need to take note of, and even to the extent of giving us examples of training centers that can be approached for data protection training. So thank you so much. Oh, sorry, one more question. One person has the final question. Data protection policies as provided in draft regulations, that is the basis of the question. If they do come to be law, does that mean there will be an obligation to have both data protection policy and a privacy policy?
I think that question is basically, I mean, you're just saying the same thing: potato, potato, tomato, tomato. So there are two things that an institution, I mean, in terms of policy. One, an institution needs an in-house policy that deals with how within the institution they're going to handle personal data. So these are like standard operating procedures within your institution. What kind of data you handle. That's so the in-house policy one will have the data mapping, the data inventory of the institution. What kind of data do you collect? Why do you collect it, etc. In-house, it will also indicate what are the obligations of the shareholders, directors, employees, members of staff, contractors, etc. So that is an in-house policy. Then we have what you call a privacy notice. A privacy notice is the information that now you provide to your data subjects. And your data subjects in this case could be your employees, could be your customers, could be your client. And the privacy notice is the information that I think I had in one of my slides. Let me just share it. I think it will be easier that way. So this is what is there in a privacy. a privacy notice. You can see the slide?
Yes, we can.
Okay, so a privacy notice will have, in a nutshell, in terms of an outline, will have this information that you give to your clients, to your employees. You'll tell them what personal data you're processing from them, why you need this data, what you will do with this data, who you're going to share this data with, how long you're going to keep this data, how secure you're going to keep this data. You also outline the rights of the data subject and contact details in case of breach. So this is information in the privacy notice. This information is, let me say, it's data subject facing. It's information you'll give your members of staff when you're hiring them. You'll give your clients, your customers, all right? But I say the distinction between privacy notice and privacy policy is that the privacy policy is the standard operating procedures that guide your institution on how to handle data. It will have provisions. The in-house policy will also state if an employee is engaged in breach, what are the disciplinary guidelines. It will clearly map out what is the role and the function of the data protection officer, how the data protection officer office ties to other departments of the institution.
Thank you so much. We have run out of time, but would you be open to sharing your slides with participants? Perhaps maybe you could email the branch and we'll be able to avail them to participants. And
yes, I'll do that.
Thank you so much. Thank you. And for any more questions, please do feel free to reach out to the branch or reach out to Mr. Leibuta on his social media platforms or on his email if he avails it. And he did mention that the ODPC would be very interested in partnering with the branch. So we'll definitely look into that just to make sure that advocates are well catered for and advocates know their rights, know which rights protect them and which rights protect their clients, and to know that they are funded 50 million and an international investigation costs 5 million is outrageous. But these are things that we will work on with time. And we absolutely appreciate the information you've shared, Mr. Leibuta. We appreciate you. We appreciate your time. And our vice chair had to step out for a minute, but she really did appreciate the time you took to share such a wealth of information with our members. Thank you for joining the webinar. Thank you for participating. And Mr. Leibuta, do you have any parting shots? If there's one last thing, if someone didn't get anything from this webinar, what's the last thing you would tell them?
Just simply, as lawyers, a legal practitioner now, you have another statute to comply with. Apart from your legal obligations and advocate-client confidentiality, you have obligation to comply with the Data Protection Act because complaints can be made against you and your firm to the Data Protection Commissioner. Thank you.
You had it. You had it. Your client can definitely report you. You can be sued. So put in line, make sure you're in line with the policies and all regulations. Make sure that your client is protected and your firm is protected. So thank you so much for being a part of this webinar. And thank you for taking time to just spend this 1 hour with us. We appreciate you and have a lovely afternoon, everyone.